Hello. This lecture is about the federal court system. And I want to make clear that that is what this lecture is about. We tend to focus, especially political science professors in American national government classes, tend to focus on the judicial branch as being the Supreme Court and talking specifically about the Supreme Court's ability to overturn laws that have been passed by Congress and approved by the President. This is a very important function of the judicial branch, and we will talk more about that in the other lecture on the court system. What I want to talk about today, however, or in this lecture, is what I've called the order in the courts, about what happens in the federal judiciary system, which 99% of which does not involve the Supreme Court. It's important to realize that the court system was designed to resolve conflicts between individuals and laws. The court system was not designed, nor is it supposed to judge the validity of all laws. It's not like every single law that gets passed has to run through the courts to make sure that it's appropriate. Laws are passed, and the court system's job is to basically sort of figure out when an individual has resolved a conflict between an individual and that law. Think of it as sort of the most basic system in the world. Somebody gets caught allegedly having shoplifted something. The role of the court is not to decide whether or not the shoplifting law is wrong. The role of the court is to say, well, here is a person who has been charged with doing something that is contrary to the law. Let's resolve how this person can live in society when they've conflicted with this law. I hope that's clear to everybody. So, logically, the question then is, well, how is a court supposed to resolve these conflicts between individuals and laws? And it's actually a very sort of logical process if you think about it and break it down into steps. So, step one, someone somewhere commits a crime, or else someone somewhere is injured by a law. And it's important to sort of declare this because a person cannot simply go to court because a law seems wrong. Courts are sort of, they catch the things after things go wrong. They catch matters after the fact. So in order for something to go to a court, either somebody has to break the law, or else somebody has to claim that the law has injured them. And when I say the law has injured them, I'm talking about something like a law that has that they have somehow discovered that they are not benefiting from, or a law that has treated them unfairly. It's important, while we're still talking about step one, where somebody is being injured or somebody has committed a crime, to sort of talk about the difference between federal courts and state courts or local courts. Because there's actually different judicial branches, just as there are different legislative branches and different everything else. State courts exist to resolve state laws. Local courts exist to resolve local laws. And state courts include, for example, the civil court and the small claims court. Small claims court is where you go if you're claiming that someone has taken something from you that is worth less than, and the value varies from state to state. In most states, it's less than $1,000. You go to small claims court, you don't need to invest in a lawyer, and it's a lot cheaper. A civil court is a case where somebody is basically suing somebody for an injury, but it's not necessarily a question of a legal matter. Federal courts resolve conflicts between individuals and federal, that is, national laws. So if I get caught speeding, this is not a violation of federal law, I would go to a local court. If I got caught speeding and had the police discovered while they were searching my vehicle that I had, a child with me who was not my child and I was crossing state lines with this child, this is a federal offense. This would get resolved in federal court. So that's step one. Somebody is found to have committed a crime. Step 2, and this is also again somewhat logical perhaps, once that person has been caught committing a crime or that person has been injured by a law, that person gets caught. And once they get caught, they have certain rights. These rights are guaranteed mostly by the Constitution. The first of these rights is a speedy trial by jury. And I pause here once again to sort of reflect that we're used to hearing that. We all watch Law and Order or other police dramas on television, so we're used to sort of hearing people's rights read. It's important to realize that each individual has the right to waive a trial and to choose to either plead guilty somewhere in the process or to have a bench trial, which is a trial by just a judge without a jury. In fact, a trial by jury of one's peers is relatively uncommon. If you consider how many crimes are committed and how many people are charged, most people will actually plead out or have a bench trial rather than go through the process of having a jury trial. A second right that everybody has if they're caught or accused of a crime, you should know this one as well, is the right against self-incrimination. It's important again to sort of delineate what this is and what this is not. What this means is that if someone on the police force asks you, "Did you do this crime?" you have the right to just not answer. However, it does not mean that you have the right to stay silent during anything. Police officer has the right to ask you your name, what you're doing, anything else that is not related to whether or not you committed a crime. Sometimes people just figure it's the right to completely clam up, and you don't have that right. You simply have the right not to say something that's going to get you into further legal trouble. The final right that I think most people are familiar with is the right to having an attorney present during any interactions with the police. And people have argued that this is somewhat of an important one because individuals may not be familiar with the nuances of various laws, or for that matter, the nuances of what rights are available to them. An attorney, someone who's versed in the law, is there to advocate for anyone accused. So that's step 2. Person is caught, interacts with the police or with other government agencies, but is protected by certain rights during this time. With these rights in place, the person accused of a crime will first go to a district court. A district court and there are varying numbers of them. There's a minimum of 1 federal district court per state. Some have more because they're more populous and they have more people in them. A federal district court, even though it is located in the state, is not the same as a state court. So it's not the same as the court for the state of Pennsylvania. It is, in fact, the federal district court for one of actually several districts in Pennsylvania, like Pittsburgh. Within the district court is the place where attorneys or people will argue the facts of the case. And the facts of the case are the questions of what did the person do, what does the law say, and are the things that the people did in fact contrary to the law? Was this person in fact carrying something that is illegal? What does the law say? What was this person carrying? At a district court, the decision is solely guilty or not guilty. Was this person in violation of the law or not? It is not the place to argue that something is unconstitutional. It is simply a place to discover whether or not the person was guilty or not guilty. At the end of this court case, if the person accused of the crime is found guilty and they're not happy with this outcome, they have the right to appeal. The appeals court is a separate system from the district courts, but it is still a federal court system. And the appeals courts are in what are called circuits. And this is a name that dates back hundreds of years, back to the days when a judge would actually ride a horse on a circuit and would visit different towns throughout the area. Circuit courts, appeals courts, are different than than district courts because there are no juries. The case is decided by a panel of judges. And within an appeals court, the facts of the case are assumed to be correct from the previous trial. What this means is that they're not arguing about whether or not this person was found carrying this item anymore. If that was in the previous trial, it's assumed to be correct. And if there's new evidence that has appeared, it doesn't go to appeals, it goes back to the district court for a real trial. Appeals can happen on a number of different reasons. Someone found guilty of a crime can appeal the conviction on grounds of errors conducted in previous trials, so the lawyer misrepresented something. A person can also appeal on grounds of having their rights violated, so that, for example, if someone was accused of carrying something that was illegal and it was an illegal search, this item was discovered during a search without a warrant, they can appeal based on the fact that their rights to privacy were violated. The third reason that a person can appeal a decision from a district court is that they've decided that the law is just wrong or unfair. The outcome of an appeals court is that the previous decision is either upheld or overturned. So either the decision from the district courts is upheld, so if that person was convicted prior, that person is still convicted, or that decision can be overturned. If it's overturned, in some cases, the entire case may go back to the district court for a retrial, a new trial with the new understandings that have come from the appeals. If the outcome of an appeals decision is unsatisfactory, people have the option of appealing to the Supreme Court. Now, and the Supreme Court is somewhat unique because the Supreme Court is both an appeals court and a district court. And we'll talk about that in a little bit. The Supreme Court, like an appeals court, has no jury, and it does not question the facts and evidence from the original trial. What it does is, once again, it's a panel of judges who decides whether or not other matters in the case, there were grounds of error or rights violated or the law was just incorrect. The Supreme Court is different from all other courts in a couple of ways. The first way is that, as I hinted earlier, it has both appellate jurisdiction and original jurisdiction. What that means is it acts sort of like a district court for certain very rare circumstances. For example, if a diplomat, somebody who's representing a foreign country in the United States, is brought to trial, they will go to trial directly to the Supreme Court, not to a district court. Another option is if there's a dispute between two states. So if Pennsylvania and Maryland got into a trade argument, they would go directly to the Supreme Court as opposed to trying to figure out whether the court in Maryland, district court in Maryland or the district court in Pennsylvania would be unbiased. I hope that last example kind of explained why the Supreme Court is the body that gets to decide that. It's just too hard to find another court that would probably be unbiased in this situation. The overwhelming majority of the cases in the Supreme Court, however, are court cases that are heard on appeal, so they come from the district courts by way of the appeals court. And the Supreme Court is unique in that it has both original and appellate jurisdiction. The Supreme Court is also rather unique in that, unlike every other court, it gets to decide what cases it hears and how. A district court, the judge and the jury will hear every case that's brought before it. Every person who is charged with a crime in that district, the district court will hear. The appeals court will hear any case that's brought on appeal from the district courts. The Supreme Court gets to decide what it wants to hear. It gets literally hundreds and hundreds of petitions every year for different cases, and it ignores the vast majority of them. It also gets to decide some of them without actually doing a hearing. It just reviews the facts and evidence, looks at the lawyers' briefs and so on, and issues a ruling. That's called a per curiam decision. The very few cases that it decides to hear, it first issues a document called a writ of certiorari. And what that means is that those are the very rare cases in which lawyers actually go to the Supreme Court to argue the case before the judges. And the judges then get to question those lawyers. The Supreme Court, third way in which the Supreme Court is different from all other courts, is that in the Supreme Court you get very conscious involvement of outside parties. And outside parties act in two different ways. The first way that outsiders get involved in Supreme Court cases is that they can act as consolidators of important cases. The most famous example that you may know of this is actually the opinion I'm having you read, Brown versus Board of Education. The Brown versus Board of Education was filed by the NAACP, a civil rights organization, and it actually managed to consolidate about a half dozen different cases, all arguing about school desegregation. The case is known as Brown versus Board because of the half dozen cases that it consolidated. The case of the Browns was the first one alphabetically. And so it's Brown versus Board of Education of Topeka, Kansas. But there are many other boards of education that were also involved in this case. So outside parties can be involved to sort of highlight the fact that a particular issue is not just an issue in this case, in the area of Topeka, Kansas, but that it was an issue for the nation. And this is important because one of the things that the Supreme Court uses to decide whether or not to hear cases is whether or not they believe that this is a case that has a national scope. The other way in which outside parties can get involved in Supreme Court cases is by filing what's called an amicus brief, or an amicus curiae brief. Amicus curiae is Latin. It means friend, amicus, of the court, curiae. And amicus curiae briefs are filed often by interest groups, sometimes by very well-known individuals, to try to show the court the implications of the case or the implications of a potential decision. I can tell you from, again, personal experience when I was working in Washington, I've sort of seen these amicus curiae briefs. They're written by lawyers. It's not just that, I can decide, well, I'm a friend of the court, because they're written by lawyers and they tend to highlight very particular things of a case. I happened to be working for an organization that represented a very particular trade body, and there was a case that was being decided by the Supreme Court, and the trade organization that I was working for wanted to make sure that the court understood exactly what the effects of this decision would be on their particular business. Lots of organizations file amicus briefs. So it could be something like the NAACP, it could be something like a faith-based organization or a church, but generally they are organizations that represent very well specified interests. The final way in which the Supreme Court is different from all other courts is that it has decisions and opinions. And while district courts and appeals courts in particular also have decisions, guilty or not guilty in the case of district courts, decision upheld or not, or overturned in the case of appeals courts, what's interesting is that often it is the opinions of the Supreme Court which are more important than the actual decision. And when I say opinions, and hopefully you'll see this when you read through the Brown versus Board of Education decision and opinions, An opinion isn't just sort of something like, well, gee, I like it when it's 75 degrees outside. An opinion goes through a very well-reasoned legal argument for why a decision was reached. So in the case of Brown versus Board of Education, the decision was that segregation was overturned. But the opinion, which wound up being much more important, spelled out why it was overturned. Opinions can be important regardless of whether they support the majority decision or not. The Supreme Court acts by vote, and there have been a number of very finely split 5-4 decisions on the Supreme Court where 5 people were in favor of a particular action and 4 were opposed. And what's fascinating is that even in those things, what you may get as many as 4 or 5 different opinions. As you know, the one justice writes the majority opinion, and someone else writes what's called a concurring opinion, where they basically sort of say, well, I agreed with what the decision that the majority made, but for different reasons. And here are the reasons that I had. You will also get dissenting opinions, where people sort of say, well, I disagree with with what everyone else said. These opinions are important for a number of reasons. Firstly, because across the country, lawyers, legal scholars, and judges are going to be reading through those opinions to understand why the court made the decision it did and in what cases this decision applies. They're also very important because they then also give a hint to in what cases this opinion might not apply. So if a court came up with a decision and it sort of said, well, we think that in all situations like this law should be overturned, it also means that if there was a case that was not like that, that decision might be upheld. This is very important because the Supreme Court has the ability to set precedent. The Supreme Court is what everybody looks to understand how the law should be interpreted. We will talk more about this in the next lecture, which is very specifically about Brown versus about the Supreme Court and how they reached a very particular decision. In between now and then, there is a simulation on district courts that I'd like you all to engage in. And I'd prefer that you do that before we talk about the Supreme Court too much, because it is very much a simulation about district courts. Hope this was all clear. Don't hesitate to contact me if you have further questions. And have a good day. Bye-bye.